contradiction that we see for different grounds, and also the inconsistencies within gender equality legislation and policy are not due to normative issues, but mainly due to the development of legislation and policies in different ways. And we saw that, for instance, there was a certain political momentum at the end of the 90s that facilitated the adoption of the 2000 directives. And we also spoke, for instance, about tensions between economic aims, business interests on the one hand, and then on the other hand, human rights, work-life balance, for instance, also on the other hand. And these different things, political momentum and these tensions, can also have an influence on the legislation and policy that are eventually adopted. And we also talked about different layers of legislation and policies, primarily the EU Charter of Fundamental Rights, and even soft law and recommendations, for instance, and how these all these elements interact can also create fragmentation and inconsistencies. So of course we talked about the hierarchy of discrimination grounds, where potentially race and ethnic discrimination could be at the top, and then perhaps sex or gender, preferring which terminology you want to use, because there's also a problem with terminology in this regard. And then maybe other grounds with age at the bottom, and we mentioned also several times gender identity, which is actually not even recognized as such in binding legislation, but only in a recital and in the case law of the Court of Justice. Still many problems remain, for instance, with sex and gender equality, even if it's supposed to be more at the top in the hierarchy, due to this fragmentation in policies which are not internally coherent. And for instance, the fact that working time is not properly considered in most work-life balance instruments is one of the main issues that Ania points in her paper. We also saw with Dagmar's presentation inconsistencies that relate to how intersectionality is considered, or actually not considered, in case law at EU level, but also at national level. And we also talked at different times during the day, and also at the end with Mark's presentation, about the need for more flexibility to accommodate needs of different types of people, obviously for disability discrimination, but also in the context of work-life balance, for pregnancy, and for care, not only for childcare, but care more broadly conceived, including elder care and different types of care. And also, of course, for religion, we discussed the Archbishop cases, and of course here we have, I still have very different opinions of what the Court of Justice has said. And even for gender identity, there could also be a need of accommodation, for instance, in the workplace, if someone is going through a change of sex, and which toilets should they use, for instance, there can be also a need for accommodation in that context. So we were talking about coherence, but I think we would like to emphasize, and this also came into the discussion at some point, are we talking about one-size-fits-all approach for all the grounds, or what are we trying to say? I don't think we are trying to argue that a one-size-fits-all approach should be convenient, because as we have seen today also, discrimination grounds have all some uniqueness to them. But I think what we're trying to do is that there's no normative justification for instance, providing protection in employment for some grounds and not providing it outside employment, as it's currently the case, or for not having an obligation to have equality bodies throughout all discrimination grounds. And regarding accommodation of different needs, even if we are not talking about a unique accommodation obligation or consideration of accommodation, but about considering that flexibility and accommodation of needs of different types of people may be necessary in different circumstances at work and also outside work. And making maybe a more express consideration in these, maybe through soft law in some cases, could be necessary. So how could more coherence be achieved? Again, this is a very difficult issue to just address in one day like today. But for instance, regarding work-life balance, one of the proposals could be considering more clearly working time issues, also within work-life balance instruments, and maybe also using more clearly gender mainstreaming throughout all policies and not just in gender equality legislation and policies. Of course, we also have instruments like the social pillar, which has just been proposed, and Stuart has helpfully reminded us that all the legislation, tends to be our main focus, and we have been arguing a lot of the legislation. We shouldn't forget that there are also soft law measures. The social partners are also very important, and so we would need to take into account, looking ahead, of course, all the combination of all these different elements. So finishing with this, I would like to thank you all again for being here with us through the day.